Welcome to the continuation of our class about torts. You may recall when we were last together, we talked about what a tort is, and we talked about how it's kind of difficult to define, but one way to look at it is it's a violation of another person's rights or a civil wrongdoing that does not arise out of contract or statutes. And then we talked about the type of torts that there are. There are intentional torts, which is what the focus of our other tort presentation was about. Then there are negligent and strict liability torts. Today we're going to be focusing on negligent and strict liability torts. Let me just go ahead here and get to the right slide. Here we go. So here we go. So we covered intentional torts in the first presentation. So if you have any questions about that or haven't had a chance to view that, please go and look at that presentation. Of course, if you have any questions about the material, please feel free to come to my office hours or raise them in class. I'd be happy to talk in more detail to address whatever questions that you have about the material. But for this presentation, let's go on and start talking about negligent torts. Negligent torts is the main or the most important category of torts. It's the most common type of tort. It's the most common type of tort that results in litigation. It's probably what you think about when you really think about what is a tort. Some people call them negligent torts, but most of the time people just call them negligence. So they leave out the word tort. But if you say negligence, you are talking about a negligent tort. So what is negligence? It's behavior that creates an unreasonable risk of harm to others. It differs from intentional tort in that the negligent tortfeasor does not intend the harm that he causes. He doesn't intend the action that his behavior causes. If I run into the back of your car because I'm on my phone and not paying attention, I did not intend to hit your car. I'm legally responsible for it, certainly, but it was not my desire that the front of my car touch the back of your car. I am probably as upset, perhaps even more upset about it than you are, because after all, I'm the one that's going to have to pay for the damage. So that's the distinction, the principal distinction from intentional torts and negligence torts. Is there that intentionality? Usually negligent torts arise when there's a failure to exercise reasonable care to protect another person or that other person's property. Okay, whenever we see the word reasonable, hopefully you're remembering to pause for a second and to think to yourself, reasonable means objective standard. Let me get that. Oops, wait a second. I'm going to have to... Okay, I'm having some technical difficulties here. Let's see, how can I... Okay, I'm having some difficulties here. I'm not quite sure how to make it better, but we'll just go with this. Objective standard, as opposed to a subjective standard. So it's not what the individual thinks. Probably when I was causing the car accident, in my subjective belief, my behavior was reasonable. I was exercising reasonable care. If I didn't think I was exercising reasonable care, I wouldn't have done what I did. So you can't rely upon your subjective opinion about whether it was reasonable or not. We're going to look at an objective standard, a standard that isn't dependent upon the quirks of my personality, but is what a reasonable person, what somebody who is not involved in the situation, how that person would perceive the situation. Okay, here are the 4 things that a plaintiff has to prove in a negligence case. This is kind of the equivalent of the 4 things we talked about in contracts. You know, we had the fact that we needed an agreement. We had the fact that there needed to be consideration. We talked about the fact that there had to be legal capacity and there had to be a legal object. And remember, you saw that on a test question. Well, look here, we had those same 4 things. Well, not the same 4 things, but the same concept. The 4 things you got to have a negligence claim. They're different, but they have the same legal importance. So this is a very important list of 4 things to know about. You will be seeing these in your near future. Hint, hint. So you need to have, there needs to be a duty that the defendant owes to the plaintiff. There has to be a breach of that duty. The defendant has to have not met that duty. If he had a duty and he did what he was supposed to do, obviously there's no valid lawsuit. So there has to be that duty. He has to have fallen short of completing that duty. There has to be a causal link between this failure to do what he was supposed to do and the harm that was caused. If he broke his duty but it didn't cause any harm, for example, let's say I'm on my phone talking away and I'm not exercising my duty to be safe to all the other drivers, I breached that duty. But if I don't actually rear-end your car, I haven't caused any damages. I've breached the duty, but I haven't resulted. There's no basis that you have for suing me. Then, of course, there has to be damages. If you happen to have a miracle car that spontaneously heals its bumper, well, you don't have any damages, and so you wouldn't be able to successfully sue me. You have to be able to point to some harm that you've suffered as a result of the incident. So let's talk about that first item. The defendant owes a duty to the plaintiff. The law establishes this duty. For example, a landowner has a duty to protect people on his or her land. An exception to that would be a trespasser, but if I invite you to a party at my house, guess what? You have a reasonable expectation that it's going to be safe when you come there, that I'm not going to have, cobras coiled, hiding behind the sofa about ready to strike at you, and I'm not going to have stairs that are missing nails that you'll fall through, breaking your neck on the way down. Or if I have hazards like that, I need to clearly mark them and warn you about them. Similarly, if I go to a business, in fact, it's even a higher duty in the case of a business. When you come in to come to my store, and I have my doors open for business, if I have some hazards, there may be a puddle that you slide on and you break your leg, then guess what? I have failed to meet my duty. A legal professional or a medical professional or some other professional has a duty when they're acting in that professional capacity to satisfy their client's needs. So if I go to my doctor and I've got a broken leg and I says, hey, my leg's really hurting badly, and he goes, oh, get over it, you're just a complainer. And he does an x-ray my leg, well, and it ends up that it was broken, and as a result of the lack of the treatment, my leg doesn't heal appropriately, I'm going to have a good claim for malpractice under those circumstances because he was the professional, I was his patient, and he didn't exercise normal care under that circumstance. So that would be an example. So you can have malpractice with chiropractors, doctors, pharmacists, paralegals, anyone that is serving that kind of function, accountants, engineers, teachers even. And again, we're going to look at that reasonable person standard. It's an objective standard. That's usually the way that these cases are going to be approached. So we said that there must be a duty, and the plaintiff must breach that duty. So there has to be some falling short of that duty. Having that cobra in my house that I invite you into is breaching the duty. Driving with my cell phone on in a very distracted way, that would be breaching the duty. Giving poor legal advice to my client would be breaching that duty. Then there also has to be causation, and there are two elements to causation. One is actual cause. This then is called the but-for causation. So let's think about this. I'm driving my car along, and I am having an argument with a friend over the telephone, and it's heated, and I'm making my point and really not paying attention to the road at all. And as a result of that high level of distraction, that is what causes me to rear-end your car. Well, it may have been that breach of my duty, that failure to keep focused on the road, that is the but-for cause. If I hadn't been distracted, I wouldn't have run it or rear-ended you. So that's an example of an actual cause, the but-for cause. This is sometimes called the factual cause. It's the cause and effect idea. If because I did A, B happens. Proximate cause is a related concept, but it is also somewhat different. It refers to kind of a matter of public policy. It's saying, look, there has to be a reasonably foreseeable connection between the breach of the duty and the cause. Let's imagine for a second that I am driving my car and really distracted and I'm, yelling at my friend and just really not paying attention, and I'm gesturing and my arms are all over the place and my face is red because I'm so angry, and the car next to me looks over and sees, oh my gosh, she's highly agitated, and he's watching me suddenly because he's not sure what's going on, and because he's looking at me, he rear ends a car. Well, you could say that I had a duty to him and to the other driver of the third car, and that I breached that duty by not being focused on the road. But it would be hard to, and you could also say that I was the actual cause of the accident. If I had been focused on the road and not yelling and emoting with my friend, that other driver wouldn't have been distracted and he wouldn't have rear-ended the other car. But it's hard to say it was a proximate cause, because really, was it foreseeable that my gesturing and my anger would so distract another driver that causes him to be in an accident? So I'd say under those circumstances, there was an actual cause, my breach of duty, but there wasn't a proximate cause. And again, the plaintiff has to prove both. And we'll talk about an example in a second where the plaintiff was not able to prove both. So we're going to give an actual example from a case. The plaintiff must also prove damages. So we've talked about there needs to be a duty. That duty needs to be breached. There has to be a causal link between the breach of the duty and the damages. And, of course, there must be damages, economic damages. The person has to be out money or something similar to money. The most common type of damages a plaintiff can seek is going to be compensatory damages. These are damages intended to compensate the plaintiff for what he or she lost. In a car accident case, you're going to sue for the damage that was the repair cost that your car is going to have to undergo in order to be back to its original condition. So it may need a new tire, it may need a new bumper, it may need some buffing, it may need some reworking of the metal, it may need some paint. There may be other problems that need to be addressed. And so once the mechanic looks at it and gives an itemized list, then we'll have a price for what it's going to cost to return the car to the pristine condition it was in prior to the accident. But the person riding the car may also have sustained personal injuries. He may need to see his doctor. He may need to have surgery. He may need a cast. He may need physical therapy. He may need to take medication, those types of things. Or he may have an injury that is not ever healable. Or never, fully healable. For example, maybe as a result of the accident, he has to have his arm amputated. Well, the wound will heal, but he will never get, the hand won't grow back, and so the quality of life will always be diminished. If he had been, say, a concert pianist, he's probably not going to be able to continue to do that if he only has one arm, and so that's looking at, well, what would he have earned if he had continued to have two arms, and what can he earn now that he only has one arm? That would be an example of his damages. Another category of damages is going to be the mental anguish type damages. It hurts to be injured. There's physical pain. There can be loss of quality of life, maybe loss of relationships. And so those are also damages. Hard to put a dollar amount to those damages, but they are genuine losses. And then, of course, we talk for a loss of wages or potential income stream. So those are examples of compensatory damages. They can be great. They can be small. Obviously, a plaintiff is more likely to find an attorney to represent him if the damages are great, but the plaintiff can sue even if they're quite small damages. But there has to be some kind of damage. Because this is a negligence category, the plaintiff, didn't intend to cause the injury. And so courts are rarely going to award the plaintiff punitive damages. Generally, you just don't get those. I'm not going to say it can never happen, but certainly it would be unlikely for that to be happening. Let's talk for a second about what punitive damages is. As you can see in the word punitive, we're talking about punishment. Punitive damages are not really intended to make the plaintiff whole. Compensatory damages do this. This is money above and beyond the amount that makes the plaintiff whole. This is designed to punish the defendant, intended to teach him a lesson. Hey, you ought not drive that way, and we're going to punish you so that next time you won't do that. I'll give an example. Imagine that Bill Gates is the person who rear-ended you. Honestly, even if you had significant damage to your car and you have some genuinely serious injuries, it's not real money to Bill Gates. He can pay you $100,000, $200,000, and he's not going to blink an eye. That's not real money to him. It's not going to affect his life choices one little bit. So he says, oh, okay, I'm just going to pay that money, and I'll continue to drive the way I have been driving. But if you say it was punitive damages, as the court says, hey, Bill, you're worth, however many billions of dollars you're worth, and we know that these $100,000 of compensatory damages is not sufficient motivation for you to change your ways, and you need to change them. So we're going to hit you with some punitive damages that are more in line with somebody of your earnings or your wealth situation. Another term for punitive damages is exemplary damages. And here the idea is we're going to make an example of this defendant so that other people who might have been considering doing the same thing that the defendant has done will say, oops, I saw what happened to that person. I certainly don't want to do this. So this would be an example. If Bill Gates get a lot of punitive damages, maybe Warren Buffett and T. Boone Pickens and other very wealthy people will say, oh, well, I saw what happened to Bill, and I just don't want to be in that category, so I'm going to fly straight and not do those things that I ought not be doing. So those are the 4 requirements that the plaintiff must prove in order to be successful in a negligent case. But let's talk about the defenses. We can have a comparative negligence standard. It used to be contributory negligence, but we're not going to talk about contributory negligence in this class because that's a dated standard. That's not the standard in Texas, and it's not the standard in almost any state nowadays. But there is some surviving of the assumption of the risk idea. And we'll talk about that. Then we'll talk about Good Samaritan statutes. Virtually every state, including Texas, has a Good Samaritan statute. We'll talk about that as we go forward. So let's look at modified comparative negligence. And this is a defense that's available in Texas. In this situation, let me give a hypothetical. This is a big case. It's called Lee versus Yellow Cab. This is a California case. You do not need to know the name of it. I'm just offering this as an example. Mrs. Lee was crossing a street, and there was a yellow cab, and the cab driver drove 3 lanes over at very high speed and runs over Mrs. Lee, and she is very, very seriously injured. And certainly the yellow cab car had a significant amount of responsibility for what happened. But to be honest, Mrs. Lee was not crossing at the crosswalk, and she hadn't looked very carefully before she had entered the intersection. If she had, obviously, she wouldn't have done it because this crazy cab driver was driving that way. So she bore some responsibility for the accident, but certainly the yellow cab driver bore a lot of responsibility for the accident. And Mrs. Lee wanted to sue Yellow Cab for her injuries, which were significant. Well, the standard at that time in California, which is where this case arose, and everywhere else, was if Mrs. Lee was even 1% responsible for the injuries that she sustained, she could not successfully sue Yellow Cab or anyone else because she should have been behaving herself. And she wasn't completely behaving herself, so she couldn't file a lawsuit. But you can see how that's unjust. Let's say Mrs. Lee had $200,000 worth of damages, and she's only 1% liable. Well, it doesn't make sense that she has to bear all of those costs. She's not a wealthy woman. This is going to be financially devastating for her. And that yellow cab driver who really, really messed up is getting away scot-free. That doesn't seem fair. So what the California Supreme Court said is that Mrs. Lee is going to still be able to sue even if she has some level of responsibility. The way that it happens in California is that if Yellow Cab is found to be 99% responsible for her injuries, and let's say her total damages are $100,000, well then Yellow Cab will be responsible for 99% of those damages, or for $99,000. Mrs. Lee is responsible for 1%, so she's going to essentially have to pay herself $1,000 or 1% of her damages. So that's how that works. And that's the way that it works in Texas and elsewhere. Now, there's a difference in the law between California and other jurisdictions when Mrs. Lee is 50% responsible or when she's more than 50% responsible. We're not going to focus on those cases. But when Mrs. Lee is less than 50% responsible, in virtually all jurisdictions nowadays, certainly Texas, Mrs. Lee would be able to sue. She'd only be able to collect from each one of the tortfeasors, the defendants who the jury finds are responsible for the accident, their percentage of responsibility, and they would multiply that by the entire damages. Okay, so the plaintiff's recovery is reduced by the plaintiff's degree of fault. And I said before, if the defendant establishes the plaintiff's negligence caused more than 50% of the harm, the defendant has no liability. This is the Texas rule. This isn't the California rule. This is the Texas rule. Let's look at assumption of the risk. This is a defense when the defendant can prove that the plaintiff voluntarily assumed the risk. Imagine that I went to a business that's a bungee jumping business, and they explained to me the risk. They said, hey, there's an element of risk with this. Some people, because there's going to be a snap when you hit the bottom of this bungee cord, and that sometimes causes people to have back problems as a result of it. And you ought not do it if you have that problem, and you have to understand that if you happen to have that problem, you're the one that's going to be responsible for that, and you need to watch this video about safety, and you need to sign this release saying, if I have a bad outcome, the bungee jumping cord company is not responsible. Under those circumstances, I decided to go ahead and do it. I was informed of the risk. I made a knowledgeable acceptance of that risk, and it's true that under those circumstances, because I assumed the risk, I'm not going to be able to successfully sue that bungee jumping cord company, assuming that they used reasonable care. Obviously, if they didn't have the correct equipment or the equipment malfunctioned or something like that, then I'm still going to be able to sue. But if everything worked appropriately and I assumed the risk, then I'm not going to be able to successfully sue. Let's look at a Good Samaritan statute. I'm going to actually have the statute on the next slide, but let's just talk about what it is. For those of you that have grown up in a Christian tradition, you might have heard this story growing up. The Good Samaritan is a parable that Jesus is quoted to having shared with his followers in the Christian Bible. And in that story, he talks about a Samaritan who was a person from another community adjacent to Israel. And in the story, the Samaritan, who, by the way, for historical reasons, Israelites and Samaritans did not get along. So there's a story of this Jewish person who was assisted by a Samaritan who was kind of his sworn enemy, but the Samaritan was a good person and wanted to help this injured Jewish person. And so in the story, he is the Good Samaritan. He offers assistance, even though he didn't have to, even though he had no special training. But he did it because he was a good person. Well, the Good Samaritan statute then says, hey, if you help somebody and you don't do it the right way and there's a bad outcome, it's okay. You can't successfully be sued. And it makes sense that we'd want to have that policy, because who would be willing to stop and help somebody if you think to yourself, wow, if I mess up and there's a bad outcome, I'm going to be sued and my assets are going to be in jeopardy. It's better that I don't even do anything and just let the person die by the side of the road. So you can see the public policy argument for having this type of statute. Let's look at what the statute is in Texas. A person who in good faith administers emergency care is not liable in civil damages for an act performed during the emergency unless the act is willfully or wantonly negligent. So you can see that, if I try to do CPR and I, push too hard or don't push hard enough or push too quick or too slow and there's a bad outcome, and I tried my best, I cannot successfully be sued. That's the Good Samaritan statute. So we've talked about negligence, and I want to reiterate again, negligence is the most important of these three categories. Now, it seems like we spent more time on intentional torts, but really negligence is the main one that we talk about in the area of torts. So let's go on, though, to our third category, which is strict liability torts. This is, how to compare it to intentional? I don't know which one's more common. It's certainly much less common than negligence torts. This is liability without fault. Both with the negligent tort and the intentional tort, the defendant, if he's found responsible, screwed up. Maybe he screwed up on purpose, maybe he screwed up on accident, but he did something wrong, or at least that's what the plaintiff is trying to prove. With a strict liability situation, the defendant honestly didn't do anything wrong. It sounds a little crazy that you can successfully sue someone when you're not even saying that they messed up. Let's look at what we have with the strict liability situation. I think it'll make more sense as we go forward. The law holds that an individual liable, even though they have no fault, when the activity that she engages satisfies three conditions. So you need to have all three of these conditions in order for there to be strict liability. The first thing is the action that she's engaging in has a risk of serious harm to people or to property. So this is not a routine thing. This is risky behavior. The behavior is so inherently dangerous that it can never be safely undertaken. There's always genuine risk associated with it. Even when I'm doing everything smart, taking every precaution, it still can work out not so well. And it's not usually performed. This is a rare situation. This isn't something that's run-of-the-mill that everybody does every day. When you have these three conditions, you can have a strict liability situation. So I'll give you an example. Dynamite blasting in a populated area. You might need to do that in order to demolish a building or build a road or do something along those lines. It might be necessary, but it's certainly risky. It does impose a risk of serious harm to people. It is inherently dangerous. You never quite know exactly how that blast is going to happen. There is definitely an element of randomness associated with it. And, of course, people don't usually explode dynamite in populated areas. Another would be keeping, say, a python in your house. That's dangerous. It can escape even if you're super, super careful, and it can kill somebody. And it's not something usually done. So those are examples of two strict liability situations. Let's talk about tort damages. There are, by the way, other strict liability situations, but these are the ones that we're going to focus on for this course. I don't want to make it sound like this is an exhaustive treatment of the topic of strict liability, but it's exhaustive for our course. That's all we need to know for this one. So we've covered intentional torts, negligent torts, and strict liability torts. Now let's look at damages. We've already kind of talked about this a little bit, so I'm going to do this kind of quickly. I talked about what compensatory damages are. These are damages designed to make the plaintiff or the victim whole. And we've already talked about, I don't have a dash there, but this should be just word damages. Attorney's fees are not considered compensatory damages, and in a tort claim, most of the time, attorney's fees cannot be collected by the plaintiff. Well, FYI there, different fact than perhaps you might have thought. Let's talk about the topic of nominal damages. Nominal damages, and you can see here we have, for those of y'all that have some familiarity with French, you see the word nom, or name in French. And so the nominal damages are damages in name only. They're symbolic damages. In this case, the plaintiff really had no economic damages, but the jury has said, you know what, the defendant did something that he ought not, and it just so happens that it didn't cause any compensable damages for this plaintiff, but we want to symbolically hold the defendant responsible. So we're going to say there's nominal damages of $1. Or maybe $10 or something like that. Just a very small amount of money. That's what nominal damages are. They're not rare. They're not commonly given, but it can happen. Then we already talked about punitive damages. If punitive damages are too excessive compared to the compensatory damages, a court may reduce it. It does sometimes raise constitutional arguments, specifically Amendment 8 issues about excessive fines. Okay, now we're going to talk about Palsgraf v. Long Island Railroad. I have posted this opinion on Blackboard. You are not required to read it, but you do need to be familiar with what I'm going to tell you, what I'm covering on this PowerPoint. And you may find it interesting and helpful to read the opinion. I'm certainly not discouraging you from doing that, but if you have grasped the material from what I said in this lecture, you are not required to go further. So what are the issues that the Palsgraf case talks about? Well, the issues are how is the duty of good care that is owed to a particular plaintiff, how do you determine it? How do you determine how careful I have to be? For example, when I'm driving that car, am I not exercising due care if I have my radio on? Am I not exercising due care if I'm having a conversation with someone else in my car? Am I not exercising due care if I happen to be thinking about the groceries I need to buy at the grocery store? Most of us would say that no, those would not be examples of not meeting your duty of due care. You're not concentrating perhaps the absolute most you possibly could, But we'd say that's probably not the standard. But you can see if we had a student that says, well, you know what, no radio, no phone, no conversation, no distractions whatsoever, or you're not meeting your duty of good care, probably would mean there'd be fewer car accidents. Of course, it would also mean that we'd be having a less pleasant time for those of us that travel a significant distance. We'd be not enjoying our travel time as much. Another issue is, who do we owe the duty to? Do we owe the duty to everyone in the world? When I drive my car, the other people in the other cars that I'm passing or that are passing me, I, for the most part, don't know them. Probably will never see them. I probably don't even look at them. I couldn't even tell you whether that person in the blue car is a man or a woman, or what age they are. And I certainly don't know their name, and they don't know my name. So it's a very anonymous process. Do I owe them a duty? Do I owe people? I'll give you an example. Let's say that we're driving on the road, and I rear-end your car, and you're on the phone with your grandma, who is in California at the time, and at the time that I rear-end your car, you say, oh, my gosh, because you're so startled. And your grandma, the other end of the call, thinks that something really horrible has happened because the phone goes dead. And grandma thinks you've been killed, and grandma has a heart attack and dies. Well, under those circumstances, maybe your family sues me because of grandma's death. Is grandma, who lives in California, someone I owe a duty of due care to while I'm driving a car in Collin County? That's an interesting question to make. Those are what we're focusing on in the Palsgraf case. Well, let's talk about the facts. Mrs. Palsgraf is the plaintiff, and this case was a long time ago. Let's see what the actual year is. Do we have it? I don't have it here. But it was early 1900s. I guess I don't have it anywhere. Sorry. Here we go. I guess I don't have it. So sorry. But it's a long time ago. And she was standing on a Long Island Railroad train platform. So we're in New York here. And while she's standing there waiting for her train, two men are running to catch a train. And the second man is kind of bizarrely carrying a package of fireworks. And when he gets on, he is helped by one of the train guards. He's kind of helping the man to get up on the train. And the second man drops his package with the fireworks in it. Well, guess what? The fireworks explode when it hits the tracks. I guess the tracks are hot because of the hot sun, or maybe because of the fact that the train has been riding on them. And they explode. Well, the explosion doesn't hurt Mrs. Palsgraf. But what happens is the shock of the explosion causes the scales that are used to weigh luggage, and again, this is a different era, way at the other end of the platform to fall down. Just the vibrations of it cause it to fall down. Well, the scales hit Mrs. Palsgraf, and poor Mrs. Palsgraf falls and is seriously injured. Now, everyone agrees Mrs. Palsgraf was seriously injured. Everyone agrees that she did nothing wrong. But the question is, and clearly there's a but-for causation issue here. Clearly, if the man hadn't had fireworks and if he hadn't been jostled by the railroad employee, then he wouldn't have dropped the fireworks. And if he hadn't dropped the fireworks, they wouldn't have exploded. And if they hadn't exploded, it wouldn't have caused the shock wave that caused the scales to fall over. So clearly a but-for cause of it is the jostling of the second man's arm by the railroad employee. But what about proximate causation? Was it really foreseeable for that railroad employee, as he's helping the man on and accidentally knocks his arm, was it really reasonable for him to think, if I don't carefully help this man but kind of am a little bit rough with him, he might drop his package. And if he drops his package, that package might include fireworks. And if he drops that package that might include fireworks, those fireworks might explode. And if that package that might include fireworks explodes, it might cause a vibration that causes that scale way across this train track. It might cause that scale to fall over. And if that scale falls over, it might actually hit that woman that I can barely see from here. Don't know her name, don't know anything about her, but it might hit that woman and she might get hurt. Now, we all would realize there is no way that guard would have had any of those thoughts. It's not foreseeable. It happens, so it's not impossible, but it's certainly not anticipatable that there would be that train of events. Okay, well, so that's the fact. Let's look at the procedural history. Mrs. Palsgraf sued Long Island Railroad. Now, you may be thinking, well, gosh, why didn't she sue the idiot that was carrying fireworks onto a train? Well, she might have sued him as well, but a strategy that's important to know if you ever become a plaintiff's attorney is when you're a plaintiff, you're looking for what's called a deep pocket. And most of the time individuals, unless it is Bill Gates or Warren Buffett or someone the equivalent, they don't have deep pockets. Trust me, a man who carries fireworks onto a train does not have a lot of money. And so while Mrs. Palsgraf could sue him and almost certainly win, or very possibly win, I'll put it that way, what are you going to win? He doesn't have any money. There's no benefit to winning a lawsuit when you can't collect any kind of judgment. But Long Island Railroad, very deep pockets. So that makes a much more appealing defendant in this case. So in this case, Mrs. Palsgraf won at the trial court level, and the railroad said, well, wait a second, we don't like this, we're going to appeal. And then on appeal, Mrs. Palsgraf still won. So she won at trial, she's running on appeal, and now there's another appeal. That's where we are. So this is what's taking us to this latest and greatest case, court. And this is what the court held. And there actually were two decisions in this. We're not going to talk about it here, but just so you'll know, there was a majority decision and there was a dissent. They're both very famous documents, but we're going to focus on the majority opinion because obviously that's the one that won. And this is the holding. A duty that is owed, in other words, the duty that Long Island Railroad and its employees owed, must be determined from the risk that can reasonably be foreseen in the circumstances. We already discussed how, honestly, there's no way that railroad employee could have reasonably foreseen. Again, when we see reasonable, we think objective. If we were a pigeon flying overhead viewing this scene, we would not have thought, oh my gosh, that a railroad employee should be concerned that what he's doing right now might cause Mrs. Palsgraf to be injured. No, that would not have been a thought process that any pigeon or any person who was viewing this scene from a distance would have surmised. Okay, so it must be reasonably foreseeable. This is not good news for Mrs. Palsgraf. Good news for the Long Island Railroad Company. Let's look at the next one. A defendant owes a duty of care, so Long Island Railroad owes a duty of care only to those who are in the reasonably foreseeable zone of danger. Well, remember, Mrs. Palsgraf is quite a bit away from that scene, and the Long Island Railroad employee had no idea there was fireworks to begin with. So, it would be foreseeable that the Long Island Railroad employee might have hurt the man who was actually carrying the fireworks, might have hurt, if the man had fallen on top of maybe the person behind him in line, might have hurt that person. But it's really hard to imagine how jostling somebody as he's boarding the train could hurt somebody 10 and 20 and 30 and 50 feet away. So Mrs. Palsgraf was not in that reasonably foreseeable zone of danger. Obviously, she really was in a zone of danger, the real zone of danger, but it wasn't foreseeable that she was in that zone of danger. The court held that the conduct of Long Island Railroad's guard was wrongful in relation to the man carrying the parcel. So the guard shouldn't have jostled the guy carrying the parcel, but it wasn't wrongful with respect to Miss Palsgraf. She was just too far away. No one was on notice that the package contained fireworks. The guard had no idea, which when dropped could harm a person as far from the zone of danger as Miss Palsgraf. So the judgment was reversed. Long Island Railroad won. Mrs. Palsgraf didn't get any money, and the judgment for Long Island Railroad was entered. So that is an important case to know about. If you have any questions about this material, I invite you to make a notation of those, bring them to class, or bring them to my office hours, and we can talk in more detail about this. This concludes our presentation about Chapter 5, the chapter on torts. Of course, you'll want to review the other PowerPoint WIMBA presentation for the first half of that chapter. Thank you for your attention, and I'll conclude it at this time. Thank you.